Hey guys, and welcome to today's video. We've got a wild one because today we're looking at 5 different sovereign citizens in 5 different courtrooms. 3 of them are returning champions with updates to their cases. One is an American national who still thinks laws don't apply to him. And the finale features a full-blown Karen who refuses to participate in her own custody hearing at the cost of her children. So yeah, we've got a lot to cover. But before we dive in, I'd like to thank today's sponsor, Aura. Recently, AT&T revealed that over 73 million current and former customers had their data leaked onto the dark web. Just a month earlier, Dell announced a breach affecting over 49 million users. Data brokers scoop up this information and sell it to scammers, spammers, and basically anyone looking to weasel their way into your accounts, your finances, or your private life. And the more data that leaks, the easier it becomes for these bad actors to socially engineer their way into your social media, bank accounts, or identity. To give you an idea of how well Aura protects you. After setting up my account, Aura immediately removed my personal info from 18 different websites, people search engines, data aggregators, shady lookup sites, places I didn't even know were storing my information. But thanks to Aura, I don't have to worry about it. And if you suspect that one of the companies you trusted has leaked your data, you don't have to worry either. Because Aura is offering a special discount plus a 14-day free trial when you use my link, teamskeptic.ora.com, at just $12 a month. That's less than $150 a year for comprehensive digital protection. So thank you to Aura for sponsoring this video and giving me one less thing to stress about. Now, let's get into it. We're starting in Kansas with an update to a sovereign citizen I covered about 10 months ago.
I guess I'll represent myself.
Okay. You understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
I caught quite a bit of flack for that video because some viewers were convinced that he was intrinsically stupid and that I was just picking on someone who was mentally disabled. Well, let me clear that up right now, because I was absolutely right in assuming that his stupidity was more of an act than a diagnosis. Don't get me wrong, he's still spectacularly stupid in that special sovereign citizen kind of way, but clearly he's not as far gone as people claimed, because he somehow managed to negotiate probation as a punishment for several charges, including a level 5 drug felony. And let me tell you, that takes a level of awareness, manipulation, and courtroom competence that a legitimately impaired person simply wouldn't pull off. In other words, the man might be a clown, but he knows enough to juggle when it counts. So with that in mind, let's take a look at what he managed to talk his way into and how he walked the tightrope between buffoonery and legal strategy. Well enough that the court decided not to drop him straight into a jail cell.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's
Oh,
to advise you of why you're here,
oh, okay.
what your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a
Okay.
bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it. File.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
Whatever. How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll
Sure.
be around and be available for you, okay?
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay, thank you.
Are you all right? So that's the first sovereign citizen out of the way. And honestly, his whole situation plays out exactly how you'd expect. He talked his way into a pretty sweet plea deal, walked out of court like he'd just beaten the system, and then immediately proved he learned absolutely nothing by never showing up to probation. So, shocker, it got revoked. And now he's staring down the very real possibility of serving the sentence he thought he dodged. Actions, consequences, you know the drill now. With that clown car wrapped up, we're heading straight into the next hearing. And this one involves one of the most assholish sovereign citizens I have ever covered. This guy doesn't just dabble in sovereign citizen nonsense. He bathes in it, marinates in it, and sprays it onto everyone in a 5-mile radius. I'm talking about Albert Hicks.
Albert Hicks. How he got on my docket, I don't know. It's just the city of Detroit versus Albert Himmer Hicks Jr. Appearance for the record, please.
Elwood S. Ferry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own.
Your own attorney. Well, that's cute. Why don't you go ahead and put your P number on the record then? Because if you don't have a P number, you're not a licensed attorney in the state of Michigan. Now sure, you can represent yourself pro per or pro se, but you are absolutely not your own attorney. Because if you were, you'd have already been sanctioned into retirement for all the nonsense you've pulled in court so far.
An attorney. You're an attorney registered by the state of Michigan.
Licensed to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date or you want the offer in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm
trial
challenging
date.
jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those
It's not a
positions.
debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're grown.
You don't. You have a constitutionally protected right to a jury trial. What you don't have is a protected right to pick and choose between a jury trial and a bench trial. An actual attorney would know this. Now we're heading to the end of Judge Perkins' docket, where Mr. Hicks is finally about to reach the conclusion on these charges and, I mean just these charges, all right?
Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public information.
You're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a license.
I thought about that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay? All right. So the other option is we set a jury trial. And we've set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right. No, you don't have a right to either or.
Yes, I do. Of course I do.
With this outcome, I get why some people might be frustrated, but hear me out for a second. I don't personally mind living in a system that demands this level of scrutiny for a guilty conviction, because, in my opinion, a few guilty people slipping through the cracks of justice is far better than having innocent people locked up for nothing. But if there's anything you should already know about me, it's that I'm not going to leave you hanging. So I've got this clip from Judge King's courtroom where Albert Hicks is appearing on a DV case involving allegations that he assaulted his partner of more than a decade, the mother of his 2 children.
All right, I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out. Or at least mute yourself. All right, let's do this and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, D. Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SB 1442547 counts 1, 2, and 3 SB 144-27651 and SB 5008721. I'm only dealing with those matters. And the officers are not here. So we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this. I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm going to dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, so bye.
This witness will show up. So even though Mr. Hicks may have dodged his charges today, his days of free, unencumbered, and completely unlicensed travel in his little road canoe are severely numbered. Reality has a way of catching up with these guys, and it's jogging right behind him with handcuffs in its back pocket. Next, we head to Washington, where we've got an actual American national, at least by birthright, who has somehow convinced himself that this means laws simply don't apply to him. Yes, Your Honor. We've reached that part of the
attention to the look on his face as she testifies against him at his probable cause hearing.
Is that, Mr. Albert Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay, how long were you guys partners for?
Around 14 years.
What is the deal with all these sovereign citizens taking the Chile de Castro route and threatening to sue? Every judge and prosecutor within a 10-mile radius. I've even seen them threaten to sue their own court-appointed attorneys, just for showing up and putting their names on the record. It's gotten so ridiculous that a retired Michigan family court judge recently spoke in favor of a state proposition designed to protect judges and their families from this kind of harassment. This isn't some abstract complaint either. She explained that during her 8 years as presiding judge of the family court, sovereign citizens routinely filed bogus UCC liens against her and other judges. They'd attach these fake claims to the judges' homes and property, forcing the courts to hire attorneys just to get the nonsense removed. So yeah, threatening to sue a judge isn't going to help your case. What it will do is destroy any chance you had at getting a PR bond and walking out of jail for free.
I've made this special dissertation under duress pertaining to the matters of Jonathan Troy, Faifo Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status, and so I ask you, ma'am, what is your name? What is your nationality, and what is your status?
I'm Judge Grant. I am a citizen, and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued.
It is both proven and established. The court's jurisdiction is established by Michigan statute and proven by a preponderance of the evidence at your trial. If you're going to challenge the court's jurisdiction based on the established facts, such as the time, date, or location of the incident, then you need to provide evidence to support that claim. I've reviewed the case, and you were driving in the...
You need to go that route.
While I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice.
Well, I guess we can count all those previous times you were in court as missed opportunities because you didn't learn anything. You especially didn't learn that by pleading guilty to that previous charge you were on deferral for. You effectively proved to yourself that the courts do, in fact, have jurisdiction over you.
I was not driving. Again, I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.